All right, so for our next speaker, we have Wendy, Knox, Everette. Wendy is a software developer who burned out and went to law school, where she completed a concentration in national security law and interned with the FTC, FCC, and some other three-letter agencies, which I'm told, which none of the fun ones. After law school, she completed a fellowship in privacy and information security at ZwillGen. She currently lives in Seattle, where she is a senior security advisor at Leviathan Security Group. Please welcome Wendy, Knox, Everette.
Cool. You guys can hear me? So, as we just said, I am an attorney. I'm not actually a practicing attorney these days. In my past life, however, I did handle law enforcement requests for companies, and ZwillGen was actually Apple's attorneys, one of them, during the Apple versus FBI fight, which is something we're going to talk a lot about here. So none of this is legal advice. I'm not your lawyer. I know other InfoSec attorneys who do practice. I'm happy to point you their way if you have any serious legal needs, but I'm always happy to chat about this stuff. So we're going to talk about a little bit of history first. Crypto Wars 1.0 really was in the 90s with the Clipper chip and Bernstein versus US. I threw Apple versus FBI in here also because I want to talk about the history of it, but I would kind of say that like there was a 90s crypto war and there's the current one, what we have right now. So the Clipper chip, oh, and I do not have my speaker notes. One second. Actually, no, we'll do this without speaker notes. Don't mind me. All right, so the Clipper chip had this thing called Leaf. It was a physical chip that would basically do encryption for you, and basically federal agencies would hold keys to it. There was this whole system where two different agencies had to go in and put the key in to be able to unlock it. And the NSA went out to security researchers, was like, hey, will you guys help us verify the security of this thing? And Matt Blaze, who was at Bell Labs at the time, got a hold of one of these systems. And he realized that they were doing a checksum on it. And I don't have my speaker notes, so I can't get the actual number. It was something like 16,000 bits or something. It was some high number, but not ridiculously high. And he figured out it would take him about 42 minutes to essentially fuzz a number that would pass the checksum, but would not be valid. And so the system would take a encrypted message with this and go, oh, you correctly encrypted a message, and our agencies will be able to later decrypt this if we need to get the escrowed access to it. But oops, no, they weren't really. And so essentially it foiled the point of using the system. So he published this paper that you can find on his website today, Protocol Failure and Escrowed Encryption Standard. I have a sources slide at the end of this that has a link to this. So I'll release my slides later and you can, there's basically a screen full of URLs. You can go teach yourself about this stuff. But that was one of the first failures of backdoored encryption. And people talk a lot today about like, well, how is this any different from the Clipper chip? Another part of the first round of the crypto wars was the Bernstein versus US cases. There's 3 cases here because like it went up to the circuit and there's an en banc and then not en banc, which is a bunch of like legal, essentially process wrangling. It doesn't really have that much impact on the fundamental part of what was happening. As Bernstein was a professor and he had an encryption algorithm and he wanted to publish a software code that implemented this encryption algorithm and publish a paper about it. And at the time, if you had encryption that was stronger than baby, toy, Caesar ciphers or something, you had to go register under a set of regulations called the ITAR regulations, which do still exist. And they regulate things like gun sights, tanks, F-35s, whatever. If you're going to export arms, you have to register as an arms dealer. It is a super complicated body of law. Brendan and I went to a 2-day CALEA, which is like attorney education on this in Seattle this past year, and we barely skimmed the surface of it. And going alongside ITAR, there's a concept called the EARS, which is a slightly less onerous set of regulations overseen by Department of Commerce, the Bureau of Industry and Society, BIS, which are the people that got into the whole Wassenaar restricting vulnerability stuff in 2015. Anyway, Bernstein filed this case saying like, hey, I just want to publish my software. I don't want to have to go register as an arms dealer in order to release the software code. And the EFF took the case and it came out, the courts decided essentially like, yes, software is expressive. This is protected by the First Amendment. We're going to move most instances of software out from under ITAR into EAR, which is much easier. And there have been some recent updates to make it since 2016 to make it even easier to publish encryption software. So that was kind of the first round in the 90s of the crypto wars. Then we come to 2015. There's a San Bernardino shooting in November 2015. The gunman and his wife had what law enforcement thought were messages back and forth to each other using iMessage on the phone. And it turns out that the FBI got a hold of this phone, and there were also iCloud backups, and they couldn't get access to the phone. There was actually some goof ups with like, they had 24 hours that they could have, and they missed it. So basically, the FBI goes to a judge and is like, hey, we want to get a warrant to search this phone, but even though we have the warrant, we can't get access to it because of the way Apple encrypts the software. So in February 2016, a magistrate judge basically issued an order to Apple saying, you need to go help FBI serve this warrant. This warrant was lawfully issued. You need to assist them with getting access to this content. And Apple was like, whoa, like you want us to write software to break our own encryption. Like that software is really important. When your iMessages are encrypted end to end, that's protecting you from having your messages sniffed by like a cellular carrier, by someone else on your Wi-Fi network. And like, if we do this once, this is going to be very dangerous. So Apple pushed back on it. ZwillGen was one of the law firms that assisted with doing that. And Apple actually published out to the public a letter on their website, which is pretty uncommon for them to do, explaining like, hey, we're not the bad guys here. Like, we're not just saying no FBI, like we love criminals. We're trying to explain to you that this is an extremely dangerous thing to do. We can't just break the encryption or build this one custom piece of software for you, and that's it. We're gonna lock it up. We're gonna pretend we never saw it again. That is not gonna happen. And they said, we probably could actually write this software, but then it's going to exist, and how are we going to protect who's going to use it in the future? So part of what you need to know to be able to understand sort of what the sort of equities and whatever and happen in this area is that there's the Fourth Amendment and there's a bunch of statutes in this area. So I'm going to try to teach you guys Crim Pro in about 5 minutes. This is actually a 2-semester class in law school, and it's super complicated. I had to learn a lot of this once I was out of law school. So let's see how this goes. So we start with the Fourth Amendment. It creates the expectation, a reasonable expectation of privacy. Most pure Fourth Amendment law is case law, things like the Carpenter case that was before the Supreme Court recently in Riley, talking about could police officers search your cell phone when they pull you over and arrest you. There's also statutes that govern this area. Wiretap law is extremely precise about what kinds of crimes you can use wiretaps to investigate. This is actually the area I have the most experience with. I used to serve wiretap and PRTT processes for internet companies, and it's very complicated sort of stuff. The Electronic Communications Privacy Act is sort of an umbrella over this, and it also contains the Stored Communications Act. This law was written in 1986, so you can guess about how well it works with our modern like cloud world and whatever. Like in 1986, we did not have webmail. It assumes some concept equivalent to pop mail of like email that's been on the server for 30 days, like you don't need a warrant for it anymore, which is not actually how we do it anymore. But technically the statute still says this. There's also this thing that we call a network investigative warrant. These changed recently, about 2 years ago, with a change to Rule 41 of the Federal Rules of Criminal Procedure, which is a super arcane way of saying that DOJ and FBI used essentially a procedure change to be able to do many more of these. And a lot of times what these are put on child porn websites to try to get the IP addresses behind people using Tor browsers or so forth. So I actually have an example of one for you, which is not one of these Tor browser exploits. It was talking about trying to get access to an email account of someone doing basically phishing, like they got in between some business email compromise sort of stuff. It's a little bit older. So you can see here we're talking about that we're searching for evidence of a crime, and we're targeting a target email. They basically had an exploit they were trying to use to get access to this guy's email, figure out where he actually was. We didn't have, I think, an IP address at this point in time. The information that they wanted to get was the IP address, and they wanted the user agent strings they could figure out, or is this like a mobile phone or a laptop or something on the other end? And as with every warrant, you need probable cause that a crime has happened. And so this is the probable cause. They're talking about, hey, there's this wire transfer fraud. It's basically a business email compromise. And this is why we would like this. So, cool. Government has all these ways to request data using lawful access. Except tech changes a lot. Like I mentioned, the SCA was created in the 1980s. Tons has changed since then. So the All Writs Act was originally created in 1786. It's really old. It's basically one of the first criminal procedure style statutes created, except it's not actually usually used in criminal procedure. It is generally used to basically make the courts able to function. So things like we're going to issue a writ to be able to handle a will or an estate or something in a certain way, or used in a real estate case or something. It's basically the court tells someone, I need you to go do something in order for this case to progress or this investigation to go. Not very commonly used. Most states actually also have their own equivalent of it. It's considered sort of part of the enabling legislation for our modern judicial system. So in the 1970s, there was actually a case not too dissimilar to Apple versus FBI, where the FBI wanted to go get access to some phone records in order to investigate something. I think this might have been like horse betting or something. So in the 1970s, the phone system was changing. It used to be that for a wiretap, it literally was like putting alligator clips on the wires, like in the central closet. It's not like that anymore. It's all software. When I would process this stuff, I was basically doing SQL queries, essentially, through a web GUI to like return stuff. So the networks had essentially changed in the 70s, and the police come to New York Telephone, and they're like, hey, we have this wiretap order. Please do it for us. And New York Telephone is like, we can't put alligator clips in our wires anymore. It doesn't work that way. Sorry. And so the case they went and got an All Writs Act order requiring New York Telephone to comply. And the court actually said yes. This has been something we've always been able to do. New York Telephone, you changed your network. But just because you change your network doesn't mean that you no longer have to like help out with these investigations. And so we say, unreasonable burdens can't be imposed, but we don't think this is actually an unreasonable burden because you've identified a couple ways that like you could go in and assist with this. So we now have this law called CALEA. This was passed about 1994, if I remember correctly. That is the Communications Assistance for Law Enforcement Act, if I remember. This is really fun doing this with those speaker notes. It specifically says that telecom companies need to build their systems in a way such that they can help serve warrants and wiretaps and so forth. Like you can go design your system however you want, but you need to be able to help law enforcement. They come to you with a valid process. But 1994 is the start of the internet. We had the web, VoIP was just starting to be a thing and so forth. And so they went in and explicitly excluded internet services. It says, like, this does not apply to internet services. In 1994, clearly is a little different than what we had now, but they kind of had an idea of what stuff was, what we were getting. Yeah, so we say it's a fuzzy applicability to internet service companies. The FBI will try to totally tell you that, like, no, this should apply to, you know, like WhatsApp or something, like that's a messaging service. There are every so often pushes to update CALEA to make it clearer that it applies to internet service companies. But at the moment, you know, it doesn't technically, and people try to go back to New York Telephone. If you go look at the things that the government filed in the Apple versus FBI case, they're like, we already have a case using the All Writs Act saying that you must go assist with law enforcement investigation. And the reply to that is yes, that case at that time said you had to, and then Congress acted and implemented CALEA, and Congress specifically exempted internet service providers from it, so therefore that holding should no longer apply, but it's never actually been overruled or anything. You get into very fun statutory interpretation, sort of lawyer nerd fights with this stuff. So anyway, as we mentioned, the All Writs Act was the process that was used for Apple versus FBI. So what was the outcome? So we had an order from a judge in California. At around the same time, Judge Ornstein, who's a magistrate judge in Brooklyn, had a similar case before him where the FBI, I believe it was the FBI still, was asking for assistance with unlocking a cell phone that's used by a drug dealer. And Ornstein wrote this big, long opinion saying basically like, This is requiring Apple to break their security, and it's really important these days. We have so many data breaches, we have cybercrime and whatever. This is going too far. Like, we can't ask Apple to break everybody's security just so we can get some information for this one case. And there was going to be this big hearing. There were a bunch of more filings that went in. There's going to be a big hearing on it. And like the day before, the FBI put in a thing saying, no, we need like just a couple more days. Everybody's like, oh gosh, what happened? Who knew? And they came back about a week later and said, well, we were able to get into this the San Bernardino phone essentially using a software vulnerability, which essentially negated the case. Like, it was no longer a controversy anymore whether they could access it or anymore. So this is actually still fairly unsettled. There are no clear rulings saying definitively that software companies do or do not actually need to write custom code in order to assist law enforcement. And this is very much not the last that we've heard of this. They're still seeking assistance with breaking into stuff. MS-13, essentially, I believe this was also, well, actually, no, I don't remember what sort of device it was, but it was a Facebook Messenger case. It was essentially leaked that they were trying to require Facebook to go in and write a version or write some software to crack the encryption used for this. Facebook refused. They're like, we would basically have to rewrite all of Messenger's app code. It's going to get exploited by people. It's the same thing. This is unsafe. ACLU filed a process, or filed in this case, asking for essentially the government's request and Facebook's response and everything to be released. This was November 2018. I just talked to a friend who works at ACLU 2 days ago, and I was like, hey, I'm researching for this talk, and I can't find anything from November 2018. Like, what's up? And he's like, yeah, the court is sitting on it. We don't know. There's been no update in this case. Nobody actually knows what happened here. Did Facebook really do this? We don't think they did, but it's unclear. Also, you may have seen this article in New York Times recently. Here's the fun thing with doing digital civil liberties work. There are really horrible, horrible people out there doing extremely horrible things. Like, child porn is a huge problem. And DOJ is starting to shift tactics now. Instead of being like, oh, we need this stuff because of terrorism, which is what they were trying to do with San Bernardino, now they're going, well, we need to be able to get into Facebook Messenger and everything because child porn is a huge problem, which absolutely it is. This is not in dispute. The question is, how do we balance our response to this? Can we have these messaging systems that we can detect child porn with, and yet still not have them used for censorship, not break all of our digital security? It's sort of a balancing act here. We also have things like Australia, which is requiring people to go in, and they can essentially tell Australian citizens, you work for a company, I need you to go implement a backdoor, share private encryption keys, and you can't tell your employer. So DOJ on October 4th in DC held what they called a lawful access summit. There's video for it up. I have a link to it at the end of this. And Barr basically gave his talk saying, you know, there's criminals out there. Criminals are using all these digital tools that we do. While we shouldn't hesitate to use cyber criminals, it shouldn't be done in a way that eviscerates society's ability to defend itself. And he's talking about like, oh, we think the tech companies are telling people that they can make themselves invisible to law enforcement, which is very much not true. You can always get metadata. These companies do a ton of work with serving warrants and wiretaps and whatever when they can. A warrant is not a essentially magic, like, give me the contents of this. A warrant is a right to go search for something, and you may or may not find it. So he talks about how there are Fourth Amendment balancing tests, which is absolutely true. There are very much Fourth Amendment balancing tests. If you go in and read the Riley and the Carpenter cases, we talk about how we do have essentially the need to track down criminals in our society, balanced against people's expectations of privacy. But that doesn't necessarily work in the world of math where encryption implies. Like, you can't really balance broken encryption. It's either backdoored or it's not. If there is a backdoor, it's extremely hard to have this only be kept in a way where the government can access it and not hackers, well, black hat hackers. There's essentially backdooring an encryption algorithm is intentionally weakening it. And Matt Blaze, who's the first person who broke the Clipper chip stuff, is basically, he's like, oh my gosh, this is always key escrow. They say it's not key escrow, they say nerd harder nerds, and then it's key escrow. And a lot of the problem with that is, how would we protect the escrowed keys? like, forget about just the algorithm also. Like, so say like the FBI and the NSA each has half a key. Like, how did they protect it? How does local law enforcement access get it? They don't have a lot of clear ways that they can articulate using this. And also, how does this even work with the global internet? So one of the problems is, well, we can mandate US companies use or like basically create these backdoored systems, but like I can connect to the internet from anywhere. Like, could I not just go to like Luxembourg and download like a Luxembourg version of Signal and use that? And one of the things too is people have been using software vulnerabilities essentially as like a pressure valve release. Like that's how the FBI got into the Apple iPhone. This is really dangerous. It creates a lot of bad sort of incentives for the government to find vulnerabilities and not share them, which they're probably doing already. Like this is the whole thing with like, does the NSA sit on a pot of exploits or not? And it's not really as good of a safety valve as we've been relying on. The other thing with the global internet is how do we say that only the US government can use this? You know, like China is going to immediately be like, hey, we need access to that. And China does actually, most of the messaging systems used within China, China expects to have access to it. And people also say, oh, well, can't we just compel people to hand over their decryption keys? So A, if you haven't actually arrested the person yet, that's not gonna work so well. And also the Fifth Amendment provides a lot of protections here. You can refuse to provide an encryption key, usually, if it's going to give access to something that will incriminate you. There is the foregone conclusion, there's very iffy applicability to biometric unlocks and so forth. So it's not as great of a solution as people might think. So essentially that's the state of the world. I have a lot of very small URLs for you here if you're interested in this sort of stuff. It starts mostly with history and goes down. The FBI Domestic Investigations and Operations Guide and the US Attorney's Manual on Electronic Surveillance are both fascinating. If you have any interest in this area and the digital civil liberties sort of stuff, I super recommend you pull them down and look at them. They're pretty cool. So I don't know if I have any time for questions. Okay, does anybody have any questions? We have a mic here. I think you want to come up to the mic and ask.
Hi, thank you for Is this on? So I'm curious how the GDRP and how it's been influencing our privacy and security laws here in the U.S. And if you can speak to that at all, if there's been any, do you think that that's helpful, or is it, how is it influencing?
So the GDPR has certainly influenced U.S. companies, and it's definitely influenced the recent California CCPA. So one of the big things that it does as an impact in this area is it kind of incentivizes companies not to hold on to that much data. They mostly do anyway, but it is sort of a push in that direction. So I'd say that's probably the biggest thing. I get very snarky about the tensions between privacy and security. So if you're primarily interested in InfoSec, like you want to see everything going over your network, you want full access to people's email accounts and whatever, and privacy, you know, like is almost a 180 interest in that. Like the interests are sometimes aligned, but not always. So I'm not sure that privacy regulation is really going to help in this area. And people are very concerned about asking for CALEA updates right now because it's assumed that it will just require backdoors for internet services, and then we have the security problems with that. Do you have any other questions? Cool. Thank you, everybody.